James Rohack, who's the president of the AMA, in order to obtain the AMA's support for his health reform proposal. So this was part of the quid pro quo for that support. And that was to explore ways of, if you will, taking the malpractice bear off of the back of doctors. And so what the Health Reform Act authorized was a series of two kinds of projects, pilot projects and demonstration projects, to explore several ideas, one of which was this idea of malpractice guidelines as safe harbors. And so the Agency for Healthcare Research and Quality, which is a research unit, if you will, or a research funding unit within the Department of Health and Human Services, called for proposals and ended up approving, granting an application by the state of Oregon to fund a $300,000 project to explore crafting broadly supported safe harbor legislative proposal that will define the legal standard of care and then to evaluate the effectiveness of this plan. So to understand where this is coming from the standpoint at least of the medical profession, you have to look at it in an historical context. The profession, as I mentioned earlier, has struggled since the beginning of the Republic, actually since before the beginning of the Republic, to assert control over the legal standard of care to which physicians are held. And this is a sort of they've waged this battle on two fronts: an internal battle to consolidate agreement over what the appropriate medical approach is, which is an internal struggle in which the regulars, the folks we now regard as mainstream medical practitioners, fought against rival schools of thought, the osteopaths, the chiropractors, homeopaths, naturopaths, during the 19th century for supremacy. And by the end of the 19th century, the regulars, as they were called, the mainstream physicians, essentially gained control. How did they do that? Well, it started out with licensure. Okay, so even in the late 1700s, states, led actually by New York City, began to pass laws that required physicians to have a license to practice medicine. The number of these laws increased during the early 19th century, but then two things happened. One was that Andrew Jackson was elected president on a populist democratic platform that was blatantly anti-elitist, and in particular against the elites on the East and West Coast. And on the East Coast, this may sound eerily familiar to you, and in the context of today's campaigns. The East Coast intellectuals were primarily lawyers and physicians, and so this was a kind of reaction by the populists against the privileges that were being asserted by the professions, in particular the legal and medical professions. Also, there was a fellow named Samuel Thompson who was an entrepreneur and who basically franchised an approach to medicine which was based on the idea that everybody can treat themselves. But of course you had to pay him a franchise fee in order to find out how to do this. And so these twin movements against the sort of privileged status of the professions led to the halt in the increase in licensure laws, and in fact the repeal of these laws, so that by 1840 no state had a medical licensure law. So it was a free-for-all, and that's what really opened the doors to the proliferation of schools of thought in medicine. The American Medical Association was founded in 1847, and it was in part in response to a kind of development from the elimination of the licensure laws, and that was the proliferation of malpractice suits. Beginning of the 19th century, there were virtually no malpractice suits against physicians, although the common law recognized such suits, going back actually to 13 and 1400s. But there were essentially no suits in the United States until around 1840, and historians generally link this to the reaction of the public, or in part to the reaction of the public, to the fact that anybody could practice medicine, and many of them were doing it in rather frightening ways, injurious ways. And so there began to be an enormous burst in malpractice suits, and the formation of the American Medical Association was one of the medical profession's reactions to that. The AMA fought on a number of fronts to consolidate control over the standard of care internally against the so-called irregulars, the osteopaths and homeopaths and so on. And one of the things they pushed for was the reinstitution of licensure laws. And so by the end of the 19th century, all states had adopted some form of a licensure requirement again. And in addition, they fought a battle, particularly at the very turn of the 20th century, to consolidate control over medical education. One of the characteristics of medical education in the 19th century was that it was an entrepreneurial free-for-all, much like the practice itself. Anybody could open a medical school, anybody could grant a diploma, and this essentially, and to the extent that you needed a diploma or to get a license, this basically let anybody who could get into one of these large number of medical schools to get a license. So the AMA, as you may have heard of the Flexner Report, which was a program that the AMA sponsored with the Carnegie Foundation in the early 20th century, first decade of the 20th century, in which the AMA studied the problems created by this sort of lax system of medical education, and basically asserted control over medical education. In order to get a license, you had to graduate from an approved medical school, and the AMA had a committee, a council on medical education, that was the approving body. One of the consequences of this was that the number of medical schools dropped significantly until there were very, very few by the second decade of the 20th century. So these twin efforts, licensure and consolidation of control over medical education, essentially cemented the profession's control over the standard of care insofar as it was the mainstream medical approach, what we now call the modern scientific approach to medicine, which emerged triumphant. There was also a battle. There was also a battle over the external control of the standard of care, with the medical profession during the 19th century seeking to assert its control over the legal standard that would be applied to medical professionals, and so that you have this proliferation of. Can you all see the Yeah. So you have this proliferation of malpractice suits starting in the mid-19th century, and so this was essentially an attack, an inroad into the sort of autonomy of the medical profession by external forces, in particular the legal system, in particular the judicial system, as represented by tort actions. And there were a number of reasons for this proliferation of malpractice suits. I mentioned the sort of reaction to the free-for-all that resulted from the Jacksonians and the Thomsonians. There was also a disenchantment with the mainstream medical practices of the time, which were primarily consisted of three approaches: bleeding, purging, and blistering. And this is bleeding. Bleeding has a little bit of a beneficial effect, it turns out, but it was way overused during the 19th century. Blistering had essentially no beneficial effect, caused great pain and suffering, and purging just made patients very weak, which allowed them to succumb to their illnesses. So there was a reaction against that, and also the medical profession itself was stimulating malpractice suits, because physicians were bringing or encouraging patients to sue other doctors who were competitors. And in addition, the regulars were using malpractice suits against the irregulars. And so the AMA asserted its control over its own members by, for example, getting the local medical societies, the AMA is essentially a federation of local and state medical societies, to prohibit their members from testifying as experts against other members. They also went after plaintiffs' experts in particular, something that they've also begun doing again in the last 15 or 20 years, particularly in Ohio, very strong efforts by the Ohio State Medical Association. They also actually began defending suits on behalf of their members, something that they do in Britain, and this is why it's said that there are very few malpractice suits against physicians in Britain, because they're all defended by the British Medical Association. Well, the AMA did that at the turn of the 20th century as well, and I'm sorry, the local medical societies did, and also they provided their members with cheap medical insurance, cheap malpractice insurance. Which actually cut both ways, because that also made just every physician who had malpractice insurance a convenient target for a malpractice suit. But they also, at the same time, lobbied for changes in the legal standard of care itself. And during the 20th century, I don't know, do any of you have me for torts? During the 19th century, the predominant standard of care to which physicians were held was the standard of care of a reasonable physician, the same standard of care that everyone is held to under the tort system. Beginning in the mid-19th century, the AMA got treatise writers, academics, and others to urge a change in that standard, to adopt two changes. One was to hold physicians to the standard of care of physicians where they practiced in the same locality, and the other was to hold physicians not to a reasonable standard of care, but to a customary standard of care, the standard of care that was the custom in the community in which they practiced. And these efforts culminated in a single Vermont Supreme Court case in 1876, Haythorne versus Richmond, where the court essentially adopted simultaneously both rules. Without speaking very much about it, the plaintiff's lawyer actually protested at the effect that these rules would have on the ability of patients to bring malpractice actions. The court essentially disregarded the plaintiff's arguments in the briefs and went ahead and adopted this language the language that says that essentially it's the standard of care of physicians in the same locality that is customary in terms of what they're supposed to do. Now, it's important, the locality standard I think you're all probably familiar with, and that essentially meant that if you were a sole practitioner, you could not be sued for malpractice because there were no experts who were familiar with the standard of care in your community other than yourself, so the plaintiff couldn't find any experts. Even if there were other practitioners in the area, because in part of the pressure their medical societies put on them, they tended not to want to testify against their colleagues. And plaintiffs could not go outside their communities to get experts under this standard. In terms of the customary standard, it's interesting to understand what that change meant. That is, the change from the reasonable standard of care to the care that is customary in the community. You might think that that would require plaintiffs, experts, to introduce evidence of what doctors actually did. In other words, some kind of empirical data, surveying doctors, observing them, and introducing, empirical evidence of these observations. Well, it turns out that's not what happens. In fact, there's only one reported case in all of American law in which a court actually allowed the introduction of a practitioner survey, and it just simply referred to it. It wasn't a key issue in the case. No other case reported, that is, involves one of these, any kind of empirical evidence of custom. What it does do is it sort of sets it establishes the language that the experts must use. In other words, the doctor did or did not follow the standard of care that is customary. But in addition, it eliminated or reduced the ability of judges and juries to second guess what the experts were saying. And this was particularly important where the experts agreed on what the standard of care was. I don't know, how many of you remember the Helen versus Carey case from law school? Any of you remember that? It was a kind of a remarkable case because it was one of the few times that a court second-guessed the experts in medicine. That was an ophthalmology case where a patient came down with glaucoma. and she had not been given routine glaucoma tests because she was under 40, and the standard, the custom at the time was only to give routine glaucoma tests, those little puff tests or the pushing on your eyeball test, if you were over 40. And and all of the experts, her experts and the defendant's experts, agreed that was the standard of care, routine testing over 40, only over 40. And yet the court in that case, Supreme Court of Washington, said, no, that standard isn't good enough. It remains the court's discretion. It's in our power to declare that the standard of care in the profession, the custom of the profession, is not adequate. It's not reasonable. Which was, of course, the way all other tort actions, that's the rule in all other tort actions except because of this custom standard in medicine. But that's very, very unusual. That Helen case is actually the only case I know of where the courts actually second-guessed the medical experts. So that's really the effective custom, okay? But nevertheless, putting these two standards, or these two principles together, locality standard and the standard of custom, the medical profession essentially was able to obtain a tremendous amount of control over the standard of care to which its members were being held. Okay? Well, this is pretty much the state of affairs until the middle of the last century, the middle of the 20th century. And at that point, starting around the mid-1960s, the control the medical profession had over both the internal, sort of consensus on what the standard was, and also on the efforts by external forces to intrude into what the standards, in setting the standard, the medical profession's power began to slip. It began to slip for a number of reasons. One was the growth of public and private health insurance, and now those who were the third-party payers were now expressing an interest in affecting the standard of care, for example, to say, you don't really need to do all those diagnostic tests. It's too expensive. It's wasting money. So there were inroads made by the third-party payers, particularly managed care, and there were also changes. There was the reaction or the pushback against medical paternalism. That's most clearly reflected in the emergence of the informed consent requirement in the late 1960s. Doctors now had to share the decision-making with their patients, and this led also to a disenchantment with mainstream medicine and the sort of reemergence or growth of alternative ways of providing medical care, what we call complementary and alternative practitioners, chiropractic, osteopathy, but also biofeedback, acupuncture, the kinds of alternative ways of practicing medicine. Those which had been very powerful in the 19th century began to reassert themselves, and by about 1985, patients made more visits to so-called alternative practitioners. There were a greater number of office visits to alternative practitioners than to the so-called mainstream, orthodox physicians. Another thing that happened was that the medical profession began to lose its power over the standard of care. The locality rule was abandoned in almost all states, and the judicial deference to the standard of custom began to disappear. 11 states and the District of Columbia abandoned the custom standard expressly in favor of a reasonableness standard, and 9 other states have done so implicitly simply by stating the standard of care is that of a reasonable profession. The other thing happened in the mid-1970s. A fellow named John Wenberg, a health services researcher at Dartmouth, began to investigate the frequency with which patients in different parts of the country receive different medical procedures. And he looked at particularly high-cost medical procedures like heart bypass surgery and carotid endarterectomies, which is kind of rotor-rooting your carotid artery. And what he found was enormous, inexplicable differences in the frequency with which patients in different parts of the country got these procedures. Patients in Boston were twice as likely to get bypass surgery, half as likely to get carotid endarterectomies, and he attempted to control for any explanation, differences in population, socioeconomic status, the severity of patient cases, differences in their conditions, and could not find any rational explanation for this. And this, by the way, was one of the major factors that led to the growth of the managed care movement, because managed care in the form of the business people who were running these insurance companies said to themselves, well, this shows doctors don't know what the right thing to do is, because it's so different in different parts of the country. Why don't we step in and begin to tell doctors what to do in order to rein in healthcare costs? Well, this embarrassed the heck out of the medical profession, these what we call the Wenberg variations, the small area variations, because up until then they had maintained that we are the experts, we know what we're doing, and Wenberg showed that there was no way to rationalize the care that people were getting in different parts of the country. So the profession began to lose a lot of its power. And it sort of has clawed back a bit, because the malpractice crises that began in the mid-1970s gave the profession an opportunity to strike back by essentially exaggerating the impact of these crises on physicians and patients and placing the blame squarely on the shoulders of the legal system. The profession lobbied successfully in states for caps on damages, eliminating joint and several liability, reducing the statute of limitations, offsets for collateral sources, pretrial screening panels, periodic payments, limits on attorneys' contingent fees, and so on. And in addition, the profession mounted a campaign to regain control over the standard of care. One of the things it did was to go after experts, plaintiffs' experts, that is, as I mentioned earlier. But another thing that it did was to set aside its historic opposition to the idea of cookbook medicine, and in the early 1990s to support the use of medical practice guidelines as safe harbors against malpractice liability. So what's a medical practice guideline? This is the standard definition from the Institute of Medicine. The Institute of Medicine is kind of it's the institution that represents primarily academic medicine, but it is probably the most respected medical entity in the country. And their definition is a practice guideline is systematically developed statements to assist practitioner and patient decisions about appropriate health care for specific clinical circumstances. So the idea was that you would get experts together and they would agree on what the appropriate thing to do in a particular circumstance was, and they would write this down and they would spread this around, and this is what doctors were supposed to do. And practice guidelines became the holy grail. It was the panacea for everything that was wrong with medicine, every problem that the medical system had. Arnold Rossoff, who is a law professor who teaches at the Wharton School, said their great promise, he said this in 2001 actually, their great promise is to improve the quality of care, help contain healthcare costs, reduce disputes about coverage under health plans, and ease the financial and other burdens of medical malpractice litigation on the healthcare system. That's a lot of things to accomplish with one idea. In 1990, David Eddy, who was one of the leading health services researchers, predicted that practice guidelines have the potential to affect the quality and cost of medical care more profoundly than all the new treatments of the past or next decade. Wow, this was a lot of promises being made for practice guidelines. They were also viewed as a way of reducing physicians' malpractice risks. So in 1982, ABC News aired a 2020 program that exposed the dangers that patients faced when they underwent general anesthesia. And this was kind of a shocker program, and it led the American Society of Anesthesiologists with the Harvard Medical School to promulgate a set of practice guidelines for how physicians should deliver, how anesthesiologists should deliver and general anesthesia, and included things like check the patient's vitals every 5 minutes, which seems to be kind of a no-brainer, but was apparently not being routinely done. And this ended up actually dramatically reducing the proliferation of this one set of anesthesia standards ended up dramatically reducing the number of patient deaths and injuries under anesthesia, also dramatically reduced the malpractice insurance premiums for anesthesiologists. So this was heralded as an example of how practice guidelines could actually take the malpractice monkey off of the medical profession's back. Well, in 1990, the legislature in Maine did something interesting. They adopted a scheme that was based on practice guidelines, but they skipped the crucial step of having the guidelines actually improve the quality of care. What the Maine legislature did was to adopt a 5-year project that authorized medical specialty societies in Maine. Initially, there were 3, radiology, orthopedics, and obstetric and gynecology, to issue practice guidelines. And furthermore, the legislation made the practice guidelines, once issued, at the administrative rules of the state. If you remember administrative law, that means that their substance could not thereafter be challenged. So patients could not say, this practice guideline is not correct, it's not valid. That was no longer possible once the notice and comment rulemaking process had been completed. And the third thing they tried to do, actually, was to have guidelines only be able to be used defensively. That is, physicians could assert that they had adhered to a guideline, and that would be an absolute defense to malpractice, but patients would not be allowed to introduce the fact that a physician had failed to follow a guideline as evidence of negligence. So it was a one-way street. The argument for that was that they needed to make it a one-way street so physicians would feel comfortable giving up some of their clinical autonomy, their discretion, to follow practice guidelines. That was the rationale for the one-way street idea. And a number of other states, Vermont, Minnesota, and Florida, adopted similar programs, and Republicans in particular in Congress pushed for federal legislation to make this what eventually became known as a safe harbors approach, nationwide. And President Clinton endorsed the idea in his 1992 campaign, and it was included as a pilot program in the Health Security Act, in his health reform legislation. Now, health reform in the 1990s, as we know, went nowhere. This is a cartoon from that time. We might see it reemerge, depending on what the Supreme Court does soon. So the health reform didn't go anywhere, and neither did any of these safe harbors programs. There were a number of reasons why they didn't go anywhere. In Maine, they ran into a slight problem, and that is that the Maine legislature previously had adopted a so-called malpractice reform that required plaintiffs to first have their claim screened by a pretrial screening panel. And then the result of the pretrial screening panel's review was admissible in the subsequent malpractice case in the trial. The problem that this created was that if the pretrial screening panel rejected the doctor's defense, that could be introduced by the plaintiff as evidence in the trial, in the malpractice action, which essentially allowed plaintiffs to use the failure to follow guidelines as an offensive tactic. In other words, it made them now two-way streets. And that so frightened doctors that only once in the 5 years this program was in effect did a doctor assert adherence to a guideline as a defense in a malpractice suit in Maine. The other states never adopted guidelines. They either let their programs languish or they repealed them. Nothing happened in Congress. And so there were a number of reasons for this, including that sort of pretrial screening quirk in Maine. But the main reason that nothing happened was that the guidelines themselves had problems. There were thousands of them, there were more than 1,000 of them, many of which had conflicting recommendations. Okay, which ones were the appropriate ones for doctors to use as defenses? Any of them? Just some? Even if there was only one guideline on a particular issue, on a particular topic, the guidelines contained escape clauses and loopholes. They said, in effect, this is what you should do in this particular case, unless you shouldn't do this. Even the anesthesia guidelines that had been so effective had this kind of an escape clause. It said, take patient vitals every 5 minutes, unless that's clinically inappropriate. Well, how can that be a standard of care? Because if a physician deviated from the standard, that could simply be because it wasn't appropriate. If they adhered to the standard, they might have done so in an inappropriate situation. But the main reason that the guidelines failed was that they essentially had no scientific background. They had no scientific basis. They were often, typically, the musings of a group of practitioners, typically what we always did or what I was taught in medical school. And that was the same kind of approach that led to those variations that John Wenberg and his colleagues at Dartmouth had found. Even if a guideline had been based on good scientific evidence, had been issued by an unbiased group of professionals, because another problem was that the groups that were issuing these guidelines typically were self-interested, right? A classic example in the 1990s, early 1990s, the American College of Rheumatology, that's the specialists who handle rheumatology problems, came out with a guideline that said that if you have arthritis, you must be treated by a board-certified rheumatologist, in other words, one of our guys. Meaning you couldn't go to a regular GP and get treatment. It would be inappropriate for a GP to treat someone for arthritis. Why'd they do this? Because they wanted all the business, right? The rheumatologists wanted all the business. Well, the American College of Physicians, representing the general practitioners, came back with their own guideline and said, no, it's perfectly appropriate for general practitioners, our members in other words, to treat patients with basic arthritis. Which one of those recommendations was appropriate? Well, the problem was they were both coming from very biased sources. Even if a guideline was produced by an unbiased source, by, for example, people on the panels who did not have, say, the conflicts of interest with, say, the drug companies that made the drugs to treat conditions that they were recommending, even if there was sound scientific support, guidelines were often stale. Right? How frequently were they being updated? So they might have been accurate and valid at one point, but by the time somebody's trying to use them as a defense in a malpractice suit, they were out of date. And yet the issuing group had not gotten around to updating them. So the Institute of Medicine, this very prestigious group of academic physicians, said in 1990, today the field of guidelines development is a confusing mix of high expectations, competing organizations, conflicting philosophies, and ill-defined or incompatible objectives. It suffers from imperfect and incomplete scientific knowledge, as well as imperfect and uneven means of applying that knowledge. Despite the good intentions of many involved parties, the enterprise lacks clearly articulated goals, coherent structures, and credible mechanisms for evaluating, improving, and coordinating guidelines development to meet social needs for good quality, affordable health care. So that was essentially the death knell. Even the AMA did not wholeheartedly support this early 1990s guidelines initiative to make them safe harbors in malpractice suits. So we now have this reemergence of this interest in malpractice in safe harbors. So the question is, are the currently available practice guidelines better, sufficiently better, that they can legitimately serve this function of delineating the standard of care in a way that is conclusive? So there's no longer going to be a battle of the experts over what the doctor should have done. The standard will be set based on the guideline. Well, the supporters of the current effort put their faith in something called evidence-based guidelines. And this is now the new panacea for controlling healthcare costs, improving healthcare quality, and solving the malpractice problem. How many of you have heard of the idea of evidence-based guidelines? How many of you heard of evidence-based medicine? Well, this was a big initiative by the Obama administration. The stimulus bill in 2009 allocated $1.1 billion federal dollars to supporting the performance of studies to create the evidence base for medical practice. So the idea was, since we can't agree on what is the appropriate thing to do in a particular case, why don't we go out and figure out what that is? Let's do studies that now compare different ways of approaching a patient's condition to see which one is best. And this is what is called comparative effectiveness research. And this was a big push by the Obama administration in its health reform initiative. This was also, by the way, what led to the attacks by the Republicans saying that what you're going to create is death panels. Because what they were concerned with about was that this comparative effectiveness research, which led to these so-called evidence-based practice guidelines, would be rationing tools, would be used by the government to ration health care that was valuable but perhaps not enough bang for the buck. And so evidence-based guidelines, the new sort of holy grail, are supposed to be based on impartial, rigorous analysis of evidence from well-designed studies and from deep clinical and scientific expertise, and the scientific evidence is supposed to come from this new sort of flood of comparative effectiveness research. The problem is that, like the early 1990s, this reliance on practice guidelines, the idea of evidence-based guidelines as solving all these problems, is once again misplaced. There's no agreement, for example, on what evidence is needed to support a guideline. The experts disagree. Is an agreement by a group of experts enough? Do you need a clinical trial? Do you need just one clinical trial? How does it have to be designed? How long ago can it have taken place to still be valid? There's no agreement on those fundamental aspects of the enterprise. And in addition, it's not clear that the evidence that they're expecting can actually be produced. Now, I don't have time to go into this at length, but the idea is to look at populations of patients in clinical trials. You give one large group of people one drug, another large group of people another drug, you see which seems to do better, and that becomes the standard of care. When patients have condition A, give them drug X. Well, if you stop to think about it, one of the things we're learning more and more, particularly through our growing knowledge of the genetics of healthcare, is that people are different. The disease that one person has, called arthritis, is very different from the arthritis disease that another person has. And furthermore, people react very idiosyncratically to different drugs and other treatments. And so this idea of taking broad population-based findings and saying they're appropriate for a specific case, a specific patient, is essentially unsound. And then, of course, if it was ever sound at one point, it's likely to no longer be, that is, the data is no longer likely to be valid today, years later when it's being asserted in a malpractice case. So this is the sort of policy basis behind this push for evidence-based guidelines, and the idea that let's let doctors assert their adherence to one of these guidelines as a conclusive absolute defense to malpractice. Well, let's assume for a moment, though, that there actually was such a guideline, that there was a trustworthy, scientifically valid guideline that actually told physicians what to do in a specific case without the loophole that said unless it isn't the right thing to do. Let's suppose there is such a guideline. Let's suppose that this comparative effectiveness initiative yields an effective guideline like this. And physicians who complied with such a guideline, I think we would all agree, would be entitled to use them persuasively in their defense, right? I mean, if there was truly a scientifically valid guideline produced by unbiased sources that said this is the right thing to do, physicians ought to be able to rely on that, right? The problem is, how would a court know one when it saw it, right? All that the physician appears to have to do is to say, look, there's this guideline produced by this group. I followed it. You can't sue me, right? The idea is to take judges and juries completely out of the picture. So the idea seems to be that any guideline, no matter who issues it, would be sufficient, would be appropriate for doctors to use as these defenses. Who's going to create these guidelines? Well, one of the things that the medical profession is insisting on is that it is the source of the guidelines, as opposed to third-party payers like health insurers, as opposed to the government, right? They're opposed to rationing. They're opposed to having non-medical experts tell them what the right thing to do is. But there is no single authoritative medical source that can issue guidelines, right? The IOM isn't in that business. It doesn't have the wherewithal to do that. The AMA is just one of medical association. There are a number of other medical associations. There are rival medical specialty groups. So without a single authoritative source, and I can't imagine how such a source could actually ever be created, given what the task would be, but without that, it would seem that any guideline issued by any medical group would have to do. perhaps including a guideline issued by the Association of American Physicians and Surgeons, whose executive director states that, quote, comparative effectiveness research won't buy anything for you, it will just pay bureaucrats and researchers, and whose newsletter describes evidence-based practice as, quote, a greater merger of state and corporate power than Mussolini's fascism. Now, what's to prevent them from issuing some guideline that practitioners can essentially hide behind? Now, from the perspective of the historical battles that medicine has waged against outside forces and also internal dissension about the standard of care, the idea that any medical group's guidelines should be able to serve as the standard of care is actually an intriguing gamble. They're gambling on something, okay? In terms of the law, so long as it corresponded to a guideline, no medical approach would be deemed incorrect, and none could be said to be better than another. By allowing virtually any guideline to define the standard of care in this fashion, the mainstream profession effectively renounces its ability to control the standard of care internally, right? Any fringe group can now issue a guideline. The alternative and complementary practitioners, the people who go out and open these strange cancer treatment centers in the Bahamas because it would be illegal to do that in this country, could issue a standard saying ours is the appropriate standard for cancer treatment, right? At that point, the medical profession has lost what it dearly attempted to win, and that was control by the mainstream scientific medical practitioners over their rivals. What does it get in return? Well, in return, the physician community as a whole, including these alternative approach people, would take external control of the standard away from the judicial system. That's the quid pro quo that they would get. Well, one question is what would happen to the quality of patient care under this? A laissez-faire, safe harbors program in which essentially any medical group could issue definitive guidelines could instigate a race to the bottom in which fringe groups like the American Association of Physicians and Surgeons could immunize their members from suit by issuing unorthodox or minimalist recommendations. Another concern is that the resulting deterioration in the quality of care could end up doing exactly what the profession fears most, and that is leading the government and other external forces to take control of the standard of care away from the profession. But in the meantime, what would justify giving the medical profession this much power? What would justify giving them this power over their standard of care, taking it away from the judicial system? Well, if you look at the sociology of the professions, and this is one of the leading reports by a sociologist named Elliot Friedson, the idea that professions should be able to regulate themselves is based on two assumptions. One is that only professionals have the knowledge and experience to enable them to evaluate the appropriateness of what they do, in this case of their care, and also that because they're professionals, they can be trusted to place the public good, in this case the interests of their patients, above their own self-interest. That's the two conditions that justify professional self-regulation. The problem is that neither of those conditions holds true for American medicine, right? As John Wenberg's studies showed, the physicians have far less expertise than they claim. And unfortunately, the profession has shown itself incapable of placing the public interest above its own. Timothy Jost, a law professor at William & Mary, decries the fact that medical practitioners increasingly view themselves as businessmen engaged in commerce rather than as professionals and gentlemen. And this reality that the medical profession is really self rather than other regarding was powerfully reinforced by the article in 2009 in the New Yorker by this surgeon named Atul Gawande, who's actually, by the way, from Ohio. He investigated why the care for patients in a town in Texas, McAllen, Texas, cost Medicare twice as much as the national average for the same care. Okay, and he concluded that this was due to the fact that, quote, a medical community came to treat patients the way some prime mortgage lenders treated home buyers, as profit centers. Well, Well, the realization that medicine is both less expert and more self-interested than it would like to believe is a major reason why the profession has lost a substantial degree of control over the standard of care, why judges are increasingly abandoning the custom standard, and why virtually all jurisdictions have abandoned the locality standard. And if the profession is unable to hold on to the powers it once exercised over the standard of care because it can no longer satisfy the conditions that legitimize it, that legitimize the substantial exercise of self-regulation, then it certainly doesn't seem entitled to the enormous increase in self-regulatory powers that would result if judges were no longer permitted to assess the validity of practice guidelines as evidence of the standard of care. One final thought. No other profession has this power. In our professional rules, there is a disclaimer in the introduction that says, by the way, these rules may not be used to establish the standard of care for lawyers. Now, it's an interesting question. Why do we have that sort of disclaimer in our own rules? It's probably for antitrust reasons, going back to Goldfarb and so on. But in fact, no other profession has this much power. And the question is, what would justify giving it to physicians? Thank you very much. Now you can see why I asked if there were any physicians in the audience. Questions? Yes, comments? Oh, sorry.
Yeah, hi. I enjoyed your talk. And about 40 minutes ago, you mentioned about how the AMA was going after plaintiffs' experts. Now, I really am curious what you meant, because you didn't expand upon that.
Yeah, well, it's not just the AMA, it's local and state medical societies, and it's also occasionally defendants, in other words, physicians, who feel that they've been unfairly treated by the other side's experts in a case and go after the expert for various misdeeds. But the medical profession is, for example, there's a dispute over whether acting as an expert is the practice of medicine or not. If it's not the practice of medicine, then the state medical boards and the medical groups have no power over their members when they do that, any more than they'd have power over their members when they play golf. But if it is the practice of medicine, then local and state and federal and national medical groups are saying, you're practicing medicine when you testify, and you have to follow our standards for how to do this, and basically you have to testify based on appropriate basis. So it gets into the Daubert and Fry issues, but only from the defendant's viewpoint. And so they have actually excommunicated members who have testified for plaintiff's experts. They have thrown them out of membership of their organizations, and this can have serious practical repercussions in terms of affecting their licensure and also their ability to have admitting privileges at hospitals. So that's one of the main things that groups have done. And there was a lawsuit brought by a plaintiff's expert in the Seventh Circuit against this practice. And one of the arguments the plaintiff made was, the only time they go after experts is when they're plaintiff's experts. They don't go after defendant's experts. Doesn't that show that this should not be allowed? And Richard Posner, whom you may know of, was the judge who decided that, and his answer was, well, of course they're going to go after only the plaintiff's experts. Look who they're representing. They're in business for their members, and that's perfectly legitimate. So that's what happened.
If I got you right, part of the impetus for evidence-based guidelines is to gain support for Obama's health care plan. Is that correct? That
is what is behind the Obama administration of the support for practice guidelines as safe harbors.
And my question then is, what is the status of establishing these guidelines? Where are we on that effort?
Well, that's what I was sort of predicting what would happen. The AHRQ is giving out money to conduct these comparative effectiveness studies. The big question is, can we do this kind of research without actually doing clinical trials? In other words, can we go back and mine the patient records and somehow tease out from existing medical records what the appropriate thing to do was in a particular patient's case? This then ties in with the push for electronic medical records. So the idea is, if we all have electronic medical records, all our records are on a computer, and they are standardized. That is, every record is inputted according to the same rules, then conceivably these data miners, these researchers can go in and maybe figure out, well, why did this patient die and this patient go home? The patient who died got twice as much of the drug than the other patient, and so on. This is a lot of assumptions, though. A lot time. That's right. And by the time you finish this, isn't it out of date already? So how often do you have to redo these studies? The problem, of course, is don't ask me what the solution is. Well, the solution, as far as safe harbors is concerned, by the way, my research assistant and I looked at every reported case in which practice guidelines were used as evidence by either party. And they're about, since 1970. And there are about 50 cases that are reported. And these cases, the guidelines are used differently. They're used by plaintiffs. They're used by defendants. In some cases, they are some evidence of negligence or non-negligence. In other cases, they have more of a presumptive effect. In no case does a court say that the guidelines are being used inappropriately, and medical experts who've looked at these cases say, no, these are legitimate, appropriate uses of practice guidelines. If the practice guideline is sound and states, a valid recommendation, doctors should be able to rely on them. But you have to allow plaintiffs' lawyers to be able to question that. You have to allow judges to decide whether the guideline is admissible, and if so, how much weight to give it. Yes. I don't know who was first.
Two questions. One, is cost considered a part of these guidelines? For instance, if a test is proven, the efficacy is determined clinically, yet it is prohibitively expensive, what do you do?
Yeah, that's a really good question. The original versions of the stimulus bill, which set aside this $1.1 billion for the underlying scientific research, said that this research could then be used to design standards that would take cost into account. And Medicare should use that to decide what to pay for and what not to pay for. And that was what stimulated the attack on the basis this was death panels. And so all of that was stripped out of the stimulus bill, and it's also prohibited under PPACA, under the health reform legislation that did pass. And so you can't use cost effectiveness as a measure of what is the appropriate thing to do, which is really interesting.
And secondly, given the legal profession, the debates about constitutional interpretation, in terms of are the guidelines going to be viewed as quote-unquote living documents that can change as new technology is developed and new standards are established?
Well, they have to, right? They have to be able to change, right? And so you have this sort of floating standard. But one thing that's interesting, I didn't talk about it, is the constitutionality of a one-way street approach. You might think that's unconstitutional. I mean, how can you deprive plaintiffs from using evidence that defendants can use? I mean, isn't that a violation of the right to jury trial and so on? Turns out, although we actually do that about 4 places in the rules of evidence, we actually do allow one party to use evidence and another party not to. For example, in sexual assault cases, there are differences like that in what the prosecution and the defense can introduce for good reasons. But there are always very good reasons for doing that, which don't apply here. Turns out you can't really make a strong constitutional argument against the one-way street, which is interesting. So I don't say much about that. It's not really a good way to go. Yeah.
Well, particularly if the future does hold that these guidelines would become the safe harbor, would you not think that the next step for the plaintiff's malpractice bar would be to sue the proponent of the guideline for developing deficient guidelines?
This is an interesting idea. There's a law professor named Ronan Avraham, who is at the University of Texas, who has suggested that the way to get around who's issuing these guidelines and how can we trust them to be doing it in the public interest and is to have for-profit entities issue guidelines and to have it basically be like a free market for guidelines, but the saving provision is that plaintiffs who are injured by doctors who follow a guideline when they shouldn't have, should be able to sue the for-profit guideline issuer. It's an interesting idea. You know, it's what kind of thing policy wonk will come up with in the middle of the night. Highly impractical. For example, who's going to pay for these? Who's going to pay for these guidelines to be produced by these for-profit enterprises? There are problems. I mean, so do you know about there's underwriters laboratories, consumers union occasionally have been sued for coming out with what are regarded as inappropriate recommendations, and largely my understanding is those suits are largely not successful for a variety of reasons.
I'm a little bit interested in how you would respond to this, because it's a safe harbor. The concept of following the guideline is a safe harbor. Well, the doctor could follow the guideline, but he could do it poorly.
Right. So the courts would presumably still have to decide whether the doctor in fact followed the guideline, right? And that includes performing whatever the guideline recommends in an appropriate fashion. So that would still remain. But the so-called battle of the experts, in which the dispute is over, well, what was the appropriate thing to do, or what was the appropriate way to do it? So one question you're raising, which is very important, is how detailed are the guidelines? Yeah, do bypass surgery, fine. Can I do it when I'm drunk? I mean, how specific is it going to be? What suture size should you use, and so on. So yeah, that the less specific, the less definitive they should be. But the problem is that this sort of policy approach might make them definitive, so that if as long as you followed the general guideline, you're immune, no matter how you did it. That's a good point. Well, it's 9:30, so you can I'll go off to your real world, and I'll go off to my ivory tower. But thank you very much. Hope to see you another one of these.